May I please judge you? I am appearing on behalf of Mr. M.A. Sheikh. He's on the way.
Accordingly, the conviction of the appellant under Section 304 Part 1 IPC is set aside, and the appellant is convicted under Section 304 Part 2 of IPC, and accordingly, accused, namely Somed Ali, is awarded a sentence of 7 years of rigorous imprisonment.
Next.
Item 2.
Accordingly, this criminal petition stands allowed by setting aside and quashing the criminal proceeding arising out of FIR dated 6/2/2023, registered as Titabar PS case number 24/2023, corresponding to GR case number 52 of 2023 under Section 420, 468/506/120B IPC. While parting with the record, it is made clear that the observation made in this petition is for the purpose of dealing with the exercise of power under Section 482, and such observations shall not have any bearing on the merit of the civil suit pending between the parties.
Obliged.
Accordingly, following determinations are recorded in terms of the discussion and reason given herein above. The prescription made under subsection 5 of Section 11 of the Act 2021 is relatable only to a situation/stage when authorized officer exercises its power under subsection 3 of Section 11 of the Act 2021 or under subsection 14 of Section 11 of the Act 2021 and reports the same to the judicial magistrate first class in terms of subsection 4 of Section 11 of the Act 2021. Chapter 34 of the Code shall be applicable to a proceeding under the Act 2021. Therefore, when an application under Section 451 or 457 of CRPC is made, such applications is to be determined in terms of the law laid down by the Honorable Apex Court in the case of Sundar Bhai Ambala. A revision either under Section 401, 397 or 482 of CRPC shall not be maintainable against an order passed in exercise of power under subsection 5 of Section 11 of the Act 2021, and appropriate remedy shall be an appeal under Section 12 of the Act 2021. No appeal shall be maintainable under Section 12 of the Act 2021 when the determination is made in an application filed under subsection 4 under Section 451 or 457 of the CRPC, as the case may be. As magistrate in exercise of power under subsection 5 of Section 11 of the Act 2021 is also empowered to hand over custody of the seized material, except cattle, even when magistrate is satisfied that a prima facie case is made out. Full stop. In view of the determination made herein above, and in view of the present, in the given facts of the present case, the petition stands allowed. Obliged. And next also same. Next is, what is the item number? Item 4 is the same. We have just held that this, you have the power, that relatable only to the stage of production, and in that case, even if power is there, all conditions, bank guarantee and all is relatable to that, and cattle cannot be granted at that stage also. And appeal will lie under Section 12. Sure. But so far relating to disposal of property under Chapter 34, then it will be normal. Yes.
I beg to mention for listing one criminal revision petition 2019 matter.
Yes.
For hearing matter. Earlier matter
you get it listed in the orders first, then we'll fix it for
it.
it.
Is already a matter listed in the hearing column, but no.
Hearing column where part 2?
No.
When?
Normal list daily.
When? So see, we will pass an order for listing of order.
Yes.
Then we'll decide whether it will hear it, not
Yes, yes,
hear it,
yes.
urgency. We
Yes.
cannot fix matter for here.
Yes, yes.
Is there any column in the mention memo for hearing?
No.
Why?
Mhm.
Why there is no column in the mention memo?
At the time, my lord, it may be listed on
Orders.
obliged.
April, if I
Yes.
also mentioned regarding yesterday's matter that your that argument was
Hmm.
concluded. Just one thing I would like to point out, Lordship, that on first occasion, first day when hearing was done, I said that there should be some nexus between death and
Uh-huh.
that I will submit one judgment. I had
You,
undertaken.
if you want, if you want, you give a short note also, written
Lordship.
note. Okay?
Lordship.
You are at liberty. You can give because we'll think of delivering it next week only.
Lordship,
So
that, I want to-
by end of this week, you can give it.
Yes.
We'll
I
use
want
our time, Saturdays and
to-
Sundays.
May I submit the judgment
Yes,
to the court master?
Yes, yes.
With obligation.
You can just bullet points your arguments also, no problem.
On 24th, Lordship, I will submit.
Yes, along with you submit.
I have also a similar, if I find,
Yes,
I will
yes,
give
yes,
it to,
yes, yes,
like any judgment.
yes.
May I please, your lordship,
Yes.
there are three matters, your lordship. Item number 15 has been listed in this court, your lordship.
Ah.
16 and 17 has been listed before the court number 21, your lordship. The same case, your lordship. Your lordship, in the three,
Okay, case number?
15, your lordship.
Huh.
And 16, 7 has been listed before court number 21, your lordship. Same matter, your lordship, complainant, same accused also same, your lordship. In all the three matters,
No,
the
there
matters
is
has been-
another matter in
Yes.
this list also.
Yes, your lordship.
Where is that?
Item number 15 in this court, your lordship.
15 in this court.
Yes.
In this court, one matter listed or two?
Item number 15 and item number 28 are from arising.
28,
Yes, your lordship.
two matters listed here and
Yes,
two other in the,
court number 21, your lordship. On all the three, in these three matters, your lordship, stay has been granted, your lordship, by this honorable court. But the trial court has traveled beyond our jurisdiction and has vacated the stay, your lordship. Kindly, the matters listed before court number 21 may be called in this.
no, no,
court,
I cannot call it up. You will have to make an application before the
Court number 21.
registry, Honorable Chief Justice will do it. I can adjourn it.
Can't adjourn the matter today, your lordship. The matter will be taken up today, your lordship.
Yes, yes.
Obliged.
I believe, I beg to mention for bail petition on 24, your lordship.
BA or AB?
BA, your lordship. Obliged.
Yes, Lordship.
Beg to mention for withdrawal of criminal petition, lordship. For 24. Much of-
When?
24. Much of.
May it please, your lordship.
Yes.
439 of CRBC,
Mhm.
and in this case, 4 accused persons. I have filed for only 2 accused persons. And second one is Omen, your lordship. No, petitioner number 1 is Omen. Yaisa Dhar. And she has also 7 years of trial, your lordship. And
Recovered from whose position? We'll call for the case there. When?
already articles recovered, your lordship.
Recovered, but
No.
it says with key manufactured, so
On third, madam, third of.
hard of.
3rd of June. Much obliged.
My please, your lordship. Lordship,
We'll have the, since allegations are serious, but
Yes.
apparently, it's money extorted from them. Is not it?
as per FIR, your lordship, I am paid nothing, your lordship.
No, paid nothing whatsoever. There's, the army say they are sympathizer, in fact, money extorted from them. If you go to the FIR,
This 10.
Lord,
so give a short date.
Lordship, actually, my father, I
No, we
received,
know everything. Father and son do some day, is not it? So as per army, you have paid money, demand was done, made, and you are sympathizer. Since all these acts are there, we just want to look into the case diary. Otherwise, we'll grant bail on the next day.
that's a very short date, may not be possible because Hapekati, my lord. On third, my lord, because today is 26.
We are unnecessarily inside. You see, you just go through the FIR
Yes,
and
sir.
And my lord, 31st, my lord.
31st.
Okay.
Obeisance.
Yeah, please, your lordship. FIR lordship is at page number 13 for 38 application at page number 13.
We'll call for the case diary.
There is nothing to recover, lordship. The affidavit,
No,
which
not
is
nothing-
alleged to be
not
have been
nothing to
forced,
recover.
that is
How
recovered.
how many affidavits you have declared forging the signature is required to be ascertained? Because that will have a serious impact on the life of many a people,
Yes.
is not it?
Ah.
Suppose you have
Only
declared
one recovered.
one recovered, forget about, you may say that no, this is only recovered, others I have given it to many.
Yes, lordship.
We'll see the case there.
Short date may kindly be given.
3rd of June, my lord.
3rd of June.
Oblige, my lord.
CD 3rd of June.
Wait, please, your lordship. Lordship,
Case
sir,
diary when?
from
30
my lord,
days shown arrested, lordship.
Lakhimpur, my lord.
We'll see.
Lordship. Let it be on 5th, my lord. 5th of-
Lordship, Lordship, analogous case that is BA 1315, that is fixed on 4/6, Lordship.
4/6, okay,
Lord, 4th.
4/6.
Highly okay.
CD 4/6.
Please, your lordship.
Yes.
Lordship, and here in this case, lordship, on the Monday was listed, lordship, and out of same FIR, another CD was available in this court, that is
Five
today.
CD is available, my lord.
Lordship, 28
But-
days in custody, lordship, and
What is the allegation?
allegation, lordship, FIR will find page number.
Who are you?
I'm lordship, I'm the landlord, lordship.
Landlord of?
Lordship, and one tanker was parked in my bay,
And what happened to the other?
and other lordship, and kindly come to page number, lordship, we'll find page number 16,
Hmm.
last para, lordship, last.
Lordship,
Number,
permission-
serial number 3, lordship.
Can it be taken after some time? CD we have to bring from the.
You could be. After something.
Published.
Kindly take up the matter with the item number 25.
25
25 is the same. He is the appearing on to item number 25.
item.
25.
Yes.
In this case, lordship, what happened, lordship?
Okay, we'll take it up. Just let the 25 come.
Yes.
Okay, we'll go see. Itu একেলা কিন্তু লোড লব দিলেন।
Here status report regarding whether case is registered or not, but my status report I have not received, my lord. Because the case has not been registered, my lord. My lord, lordship, there is a report, my lord. It is stated that no case has been registered at All Women PS.
Any information received?
Yes, my lord, received, my lord. Yes.
Why not registered the? No, any allegation or first informant report
Yes, my
filed?
lord, it is stated that, to inform you that, no case till now has been, my lord, registered, but an enquiry is going on against him. Only that is, but.
What
till-
is the allegation?
Hello, here, this application has been filed on anticipation. This application has been filed on anticipation. What has happened, Lordship? I had come across with a girl, Lordship, for marriage purpose. Thereafter, Lordship, after 2 months, it has come to my knowledge and certain facts has been revealed to me that her divorce has not been granted.
Mm.
So that was the situation. So I admittedly, honestly, Lordship, avoided communication. And then she filed
What is the
that was-
information lost before the police? Let us see that.
Nothing is there, my lord. regarding-
Heard. Assume learned counsel for the petitioner also heard Mr. MP Goswami, learned additional public prosecutors. The case of the petitioner is that the petitioner is having a relation with one lady. In bracket, name is Widel.
এইটো একো নাই, my lord.
Full stop. Relation, full stop. Subsequent, according to the petitioner, and petitioner decided to marry her. However, subsequently, he could learn that she is already married and her divorce proceeding is going on. Full stop. Accordingly, he stopped the relation with the lady. Referring to the annexer 2, MS Som submits that the said document will clearly show that the proceeding is pending before the principal judge family court number 2 as regards matrimonial dispute of the said lady. Full stop. It is on the apprehension that the lady may file a criminal case to harass the petitioner with an allegation of false promise to marry. She has approached this court seeking protection from arrest. This court, under its order dated 10/5/2024, sought instruction from the officer in charge of all women police station as to whether any case has been registered against the present applicant or not. Full stop. Today, Mr. M.P. Goswami, learned additional public prosecutor, on instruction from the officer in charge of all women police station, submits that information has been received from the lady against the petitioner. However, no FIR has yet been registered, and an inquiry is going on. Inquiry is going on. That being the position, Mr. Goswami shall produce a copy of the information received by the police station on the next date fixed, and till the next date, it is provided that no coercive action shall be taken in connection with the inquiry, or if in the event an FIR is registered on the basis of the inquiry. Full stop. The petitioner shall appear before the IO within a period of 10 days from today.
Deeply.
It is not stated that any information received, only stated that no case has been
If
registered.
any information has been, if any, huh?
Obliged, deeply obliged.
CD call করছে নাকি? CD was called for, my lord. CD not received, my lord.
Okay, when?
Who's the PS? এটা হেরি নেই। এটা মোশনত আইছে যে মোশন CD already CD call করা হয়। My lord, here this cases come up for motion, my lord. So we have to
No,
inquire,
why
my lord.
motion? Because there is no order of calling for the case diary.
Oh, that is why, my lord. But
Okay.
yes,
Oh, no, case diary is
Case
there.
diary
Yes,
is there,
case diary be called for. Okay.
yes, sir. So, my
Uh,
lord, perhaps, my lord, we
The
have
case diary call for is not received. Full stop. Accordingly, may release this matter on
on, my lord, next week, my lord, is not,
Give a date.
it's subject to my lord convenience, my lord. 31st, my lord.
31st of 31st
31/5, my lord.
in the bail hearing column.
Did look.
My lord, the informant was sharing some photos with me. Her father was harassing me. I have shown to her father that this is what your daughter is sending to me. And that is how this FIR, I do not know how 420 is here, my lord. First, father wanted to lodge the FIR. The daughter said, no, do not lodge it. Then she lodged it.
CD interim. Only on the, not for that ground, only on the ground that earlier she supported you, only because of that. Why she has then the position will want to see,
Absolutely.
not for any other reason. You will making a viral for
Definitely.
private photo will not grant me.
I'm deeply offended.
10/6, my lord.
May I please your lordship? Lordship, I'm appearing for, may I please your,
Yes.
lordship, this is a
Yes.
pre-verdict application, the FIR is at page 15, lordship. The FIR is at page 15, lordship. The allegations, the FIR is of November
Did he-
2000. Lordship, may
When?
kindly consider
Uh,
because it's a
On, my
government.
lord,
Difficult.
Lordship, the
30th
FIR
of
is of 2023, we have
Not
already
there.
appeared before the
Not there.
IO. Suddenly they have come up again searching for us, lordship.
CD, it's not possible to, either you improve your, this, network connection. CD.
Lordship, may kindly fix it on Friday.
Yeah, Friday.
Okay, you want an adjournment?
Yes, Lordship, maybe on Friday, Lordship.
Okay, on the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed on Friday.
Highly obliged, Lordship.
May I please allow?
Yes.
My lord, this is 438 bail application, my lord. Here, my lord, what happened, my lord? On the publication of the paper, we came to know some cases there, my lord. I went there, my lord. They did not register
Call for the
the
report.
and
Nothing
my
more.
lord, in similar circumstances, my lord, your lord, this honorable court passed an order, my lord. Lordship will see operative
44.
part 8, page 50, my lord.
Yes.
Page 49 and 50, my lord. In the similar type of case, my lord.
Oh, this is absolutely different.
My lord, here, my lord, what happened? My wife's delivery is tomorrow, my lord.
Maybe. We cannot give in on the basis of a paper publication.
My lord, if there is,
take
my
for-
lord, what they do, my lord, I have made in categorical statement, my lord, they register the case and same day they get the arrest. That is the tactics is going on. I made a categorical statement, my lord, lordship will see, para 9, my lord, I have made in
It will be
categorical.
difficult in this case. This is a common news article published.
My lord, only one thing, my lord, lordship, kindly, my lord, protect me for a day, my lord. And lordship call for the report, my lord. Only that much I pray, my lord, because my wife delivery is tomorrow. No one is at home.
In this country, many deliveries are being.
No, my lord, there
every
is
day.
somebody else is there, my lord,
That
no
cannot be
problem.
else.
No one is there, my lord, except myself, my lord.
Sorry, this I will not be possible. Hard.
Possible at least one day protection, my lord. Only no corrective
We are
action.
very liberal.
If there is,
We are very liberal, but this is not a fit case for grant of. There is no specific nothing on this.
my lord, lordship will see, my lord, what I have stated in para 9, my lord. Then lordship decide, my lord. What they do nowadays, my lord.
Friday you bring instruction.
Lord,
Friday.
Till then, my lord, no corrective, my lord. At least, my lord, only for day, my lord. I'm praying for day, my lord.
The present application is filed under section 438 CRPC with the background fact that certain news were published in some leading daily newspapers as regards illegal transportation of Burmese superis. Full stop. The petitioner apprehends that he may be arrested, apprehends that an FIR may be registered on the basis of such newspaper reporting, and the petitioner may be arrested. Why are you apprehending? Where is your name?
News, it is there, my lord. Lordship will see in the newspaper, my lord. কোন জায়গাটা আছে? First page, my lord. শিবসাগর বিশেষ প্রতিনিধি রাজ্যের নৈত বহি আছে কোটি কোটি টাকার মাজুদ সুপারি syndicates law. In the heading, it is there, my lord. Extreme right hand side, my lord. Page 12. Nagaland Borali Boy আছে ট্রাকের সুপারি ভান্ডার পড়া
Where is your name that you are involved? Please get where.
নেতৃত্ব লোয়া এই লাসিত. And police came to my place also, my lord.
Full stop. Come on. So in which police station?
that is the difficulty, my lord.
Which police station?
Four police stations has been missed, so my lord.
Shivsagar police station.
What? Shivsagar police station.
Shivsagar police, Golaghat and
How can it be?
Jorhat, my lord. See,
How? From where? Where will
my
bring
lord,
the
in my
instruction?
place, my lord, I have not, my lord, in my resident, they have visited, my lord, Chillaraido. Only police personnel, lordship. Soraido police station, my lord. That will do, my lord.
It is also, where is your statement that Soraido police station personnel visited your house?
What this one? Para 6, my lord, petitioner begs to, due to the news published on the newspaper, police personnel may be registered and the police personnel has visited the petitioner house.
Police personnel from which police station?
Police station, my lord, I have taken instruction, it is
No,
Saraido,
no,
my lord,
this
in
is
his
not the way to
residence.
file an application, that too without this. This is not the way.
My
You
lord,
must-
my submission be recorded,
First
my
of
lord.
all-
Saraido police station has come, my lord, because
Come
I'm
on.
resident.
No specific averment has been made which police station and from where the police has visited, though a statement at paragraph 6 is made that that some police personnel have visited the petitioner house. In the aforesaid background, it is difficult to even call for a record without there being any specific ingredients. Inasmuch as the newspaper has been published, news item has been published from Sibsagar alleging involvement of transportation of illegal Burmese supari through the district of Golaghat, Jorhat and Sibsagar. That being the position, this court is not inclined to entertain this petition. Accordingly, same stance dismissed. However, the petitioner said be at liberty to approach this court once again with better particulars and details. Yes, next case.
Yes, your lord.
May I be sure? Lordship, a notice has been served to me from Cybercrime Police Station, Prayagraj, UP, Lordship.
What is this, page 11?
Lordship, I have
When
filed,
the incident happened?
Lordship, one of my friend, 1 year back, Lordship.
No, we understand, that we know.
Fine.
One of your friend took you to a place,
Yes.
then he asked your phone number.
Yes,
Then you gave your phone number, then he opened an account. So you are not aware your OTP was used. So therefore, so on and so forth. And in that account, cybercrime was committed.
Lordship.
So UP police has called you.
Yes, Lordship.
Now, according to you, you were, when this offense was committed?
Lordship, about 1 year back, he has.
1 year back. 1 year back, what is, you were doing? What was your,
I'm a student, Lordship.
you were a
and-
student.
That time I was a higher secondary student. Now I'm a medical student.
You are a,
I'm a medical student. I am pursuing D
what is your name?
My name is Rakibul Islam.
Rakibul Islam. Now come to your affidavit.
Rakibul Islam. Oh, sorry. Lordship, age is.
If you are a 48 years age boy,
Lordship, this is
and you say that you were high secondary last year, how will you believe you?
Lordship, it is a pin mistake, Lordship.
Huh?
Practical mistake.
See, for your mistake,
In fact, it
that is an oath. He has said that my age is 48 years.
Lordship. In fact, it is his father age. Lordship.
See
Wrong.
how careless and casual you are.
Sorry, Lordship.
File afresh. The learned counsel for the petition submits that there is a defect in the present application. Accordingly, he wants to withdraw. Otherwise, will dismiss it. Withdraw this application and file afresh and give particulars that you are a medical student and all. This is not the way to deal with your clients. Yes.
God bless.
This matter may be taken up along with item number 30.
That's a number 30. Yes, Mr. Public Prosecutor, come here. Wait till 1st of July, everything will go. Now, you have taken a decision to withdraw cases. Fine? Okay, we will not find a blame on it. You have decided all cases which your offenses are up to such census will withdraw, and en masse you have withdrawn. Now, who will redress the victims if victims are aggrieved? Now you give an SOP saying that you can file an CR case. Under what provision of law? Can a SOP be part of a CRPC? Can you create a right of some person that complaint should be lie under such and such circumstances given by SOP? So why will not interfere in whichever the cases comes before us? And how you can give a remedy to a person by way of an SOP? That's why we have made this petition part heard. We want you to address on this. Hard, Mr.
Item 30.
A.M. Borguia, Learned Counsel for the petitioner. Where is the order? Which is, this is item number? 45.
Along with item number 30, my lord.
You take up item number 30. Okay, we'll take a little bit later. This is a difficult proposition.
Yes.
Just you
Understood.
think over it. If necessary, you have a talk with the Advocate General. See, 482 power, we can exercise our power. Situation is such, at least because in the new act,
Yes.
there is a provision that
Minor-
without notice you cannot withdraw.
Cannot.
And that is the actual position of law. Can a state government beyond CRPC says that you will on withdrawal, your remedy is to file a complaint. Until and unless that is given in a, if you can show that no, this is a procedure under CRPC, okay, fine.
That should be. Obliged.
Hard. Mr.
H. Agarwal.
CD interim.
Very good. Dostoevsky officer 46. 10 June notice.
10th of June.
Actually, my senior is the next in court number 13. Kindly pass over the matter for time being.
Today may not be possible because we do not know. I will have to go to visit Mr. Pranj Bora's place. So we'll have to leave early.
Tomorrow, day after tomorrow.
Day after tomorrow.
Lordship, day after tomorrow, we have picked so many matters. So, Lordship, not-
Maybe you do it
Okay, Lordship.
Yeah.
on the
Achha.
prayer of Learned Standing Council NCB. List this matter on Friday, on Thursday, 4th, not 4th, this weekend, 27.
Achha, Blai.
27 or 24, man.
24,
Or
24, Friday.
Friday.
Lordship, matter may kindly pass over for time being.
Not
My senior
timing
is-
on Monday. You go through it.
Not-
On the prayer of the Learned Council for the parties, list this matter on Mondays, 27th.
My lord, this is 439 bill application, my lord. In the meantime, we have obtained charge sheet and FSL report as well medical report, my lord. We have
Okay.
obtained and we have gone through it, my lord. But FSL report does not indicate, my lord, the matching was there, my lord.
Where is the FF?
FIR lordship will see at page 10, my lord.
Scan copies has come?
Yes,
Yes,
it has
it
come.
is there, my lord, and I have obtained certified copy also, my lord.
Where is the scan copies?
It is there, my lord, and I have obtained certified copy also, my lord. Lordship, kindly have a look the FSL report first, my lord.
These are report, medical report.
Medical report, it is there.
Take my lordship, no injury found, but the hymen was found to be ruptured.
Lordship, I got the certified copy, my lord. If your
Medical
lordship
report,
permit me, I
medical
can.
Where is the medical injury?
Lordship can have a look, my lord.
Let's can go to lordship. I take mark.
Lordship, I have
Okay,
take
okay, okay.
certified copy.
Findings are on the last page.
No evidence of sexual assault found except the ruptured hymen.
What more is required?
No, my lord. Medical.
Even,
DNA test,
even
DNA test does not match with me, my
we
lord.
are, Mr. We are not in a trial.
My lord, that is true, my lord.
In 2019, he has been giving a brief, but he didn't file it. And there's a time bar below. Now, now that has been very,
Difficult. This case is difficult.
well, definitely, well, your lordship kindly see that whether my custodial detention is necessary or not, well.
No,
Yeah.
that is not the always the case. Then in every cases,
But my lord will find the only thing what I, my lord, is, he has lost everything, my lord. He has lost. His license has gone, my lord. Everything is gone, my lord. On my lord, my lord.
was there any interim?
No, my lord, I'm BA, my lord.
Oh, BA.
BA, my lord. I am in jail, my lord. Jail, my lord.
Peruse the case diary. The present application, the affair reveals that the petitioner, who is an advocate, allegedly forced one order of the Motor Accident Claim Tribunal, Jorhat. Full stop. The petitioner was arrested on
5th of May.
5th of May 2024. The case diary is produced by the learned additional public prosecutor. Peruse the same. From the material available on record, it is clear that the investigating authority has almost completed the investigation. The forced document has already been seized and the petitioner has been thoroughly interrogated. Considering the aforesaid, this court is of the view that no further custodial of, interrogation of the petitioner may be necessary. Accordingly, the present bail application stands allowed. Where
CJM Jorhat.
CJM Jorhat, 50,000.
Oblige, my lord.
20 lordship CD has not been received. Yes.
My lord, the co-accused on the basis of whose statement I have been arrested. My lord, he has been allowed to go on bail, interim bail. And his brother was also allowed to go on anticipated bail.
Where is the affair?
FIR is at page 23, my lord. It's IPL betting and the grounds of arrest, your lordship will see what is the allegation against me.
FIR is
page 23.
When
And
were you arrested?
My lord, I was arrested on 3/5. Today is 19 days in custody. Your lordship will find in the FIR page 23, once Sri Suprit Biswas name has been mentioned, he has already been allowed to go on.
Just a minute. No. Where page 23?
Yes, my lord. Page 23. Page number.
Gurpreet Biswas, he was
Yes, ma'am.
arrested.
Arrested, allowed to go on bail. His bail order is at page 74
Just a
after 2
minute.
days. Page 74 is his bail order, madam.
Page,
74.
where is your forwarding?
Yes, madam. Forwarding, your lordship will find page 29.
Page,
Grounds of arrest, my lord, page 29.
what is your name?
My lord, my name is Nikhil Agarwal. Your lordship will find the grounds of arrest first. His name has been mentioned by the arrested accused person, Sri Bikas Beria. He has already been allowed to go on bail after 14 days in custody on interim bail, madam. And mentioned that he worked as a
Interim bill means in interim BA.
BA.
Okay.
Your-
Where is this order? Biswas
Biswas order is at page 74, my lord, after 2 days.
74. And Bikas Beria?
Because Beria online order we have annexed. Now we have also the detail order. Online order is at page 82. And detail order is here, my lord. His brother has also been allowed to go on interim bail, my lord. Okay. Because Beria's order is 9/5/20, sorry, my lord, 10/5/2024.
Here is an order 95. Okay.
9/5, your next page, 10/5.
Okay.
Bail application number 54. Oh, the name is on High Court.
He was on 14 days custody.
14 days custody. And his brother, my lord, brother also has been granted anticipatory bail on day 1. I'm told that his brother was in Sri Lanka at that time, but just nobody has come against it. But even then, he has been granted interim on day 1.
Where is
And-
that order?
I have given
This is 16.5.
Yes, madam. And earlier also, because Beria has approached this court on a number of times earlier in different years, madam. I have those orders also.
So he's habitual.
I'll not say it, madam. It's not proper to say against a person whom accusation is made
Okay.
unless he is proved guilty in accordance with law. He
No,
will face-
alleged offender is habitual, alleged habitual.
Yes, madam.
We always use the word alleged.
But only thing is, madam, disturbing.
Okay, now what is your ground?
Madam, unlike because Beria where money, mobile, everything has been recovered.
Now seizure is made from whom?
Seizure is made from him regarding mobile and money. Now,
From
police,
you, what is seized?
police says that on the statement of Bikas Beria, money has been recovered from my house. So far that money is recovered, we have given a written explanation that this is our lawful business money. And my father was ill, so we have kept some money for his treatment. In the meantime, he expired. Except the money, no mobile phone, nothing. Mobile phone is recovered, but nothing incriminating as such has been recovered.
Okay. Now, your basic ground is that parity?
The bail, my lord, what I'm
No, that co-accused are granted,
Yes.
so we'll go through the
custody
diary.
interrogation is there and already my seizure has been completed.
Period of detention, seizure is made.
Complete 19.
Co-accused granted bail, these are your ground. Yes, Mr. PP. What is the difference between him and Beria and others?
My lord, they are my lord associate each other. This is
Ah.
modus operandi, my lord. It's an organized crime.
Okay.
number one.
Hmm.
And number two, my lord, the present
Now,
petitioner.
organized crimes days will come from 1st of July.
Because my lord, without any organizing, my lord, without any, my lord, the other co-accused alone cannot be done this type of, my lord, the online games.
Yes,
my lord.
that's correct.
Yes. So
Who
my
is the
lord,
kingpin?
my lord,
According to you, who is the, as per the CD, who is the kingpin?
kingpin is the Vikas Beria, my lord. And moreover, my lord, the on interrogations only revealed that, my lord, the present petitioner was also, my lord, associated with the Vikas Beria, my lord. And during interrogation, it is found that Vikas Beria had disclosed the name of one Nikhil Agarwal and mentioned that he acted as a handler for his money associated with the IPL betting. Based on the said raid was conducted at Nikhil Agarwal residence, which led to recovery of rupees 62,80,890, which has been seized by the MR number so and so. Therefore, it is a vital for the investigations of the case. The joint custodial interrogations in this person is necessary to unearth the entire nexus associated with the IPL. That is the materials against the petitioners. That is the only materials, my lord, which I have found. And moreover, my lord, the Vikas Beria, who was, my lord, granted bail, he was also arrested, but his next date was fixed on 28 because it was an interim. Bail application interim, not an anticipatory interim, my lord. He was in custody. Thereafter, he filed an application. On the same date, this instant petitioner also filed an application, but his petition was rejected. He was gone interim only, madam. And again, next date was fixed on 28 for case diary. After case diary, we don't know what will be happening. It may be absolute.
Now,
maybe
for this is this
My lord,
order.
what has happened, I'll tell you, the disturbing fact, I may appear for a particular accused, but the disturbing fact is that on the same day when I filed my bail application along with Vikas Beria, my bail application was rejected because the counsels was different from Vikas Beria and mine. It's like show me the face, show me the law. This is a very disturbing fact in the district of Tinsukia, my lord. And your lordship, I can't produce the WhatsApp chat and the discussion that is going in the bar.
Now, where is because
I have given the order, my lord, detailed order. Your lordship will see the objection of the IO, the materials that are mentioned in the order, and ultimately granted bail.
And in this regard, my lord, I have received a copy from the Home Department that to cancellations of the Vikas Beria bail, my lord.
Even his brother, my lord, I am told that he was in Sri Lanka on that particular day when he was granted interim bail. We are not against, we have not come against the order granting him a bail order.
This is what is everything is discussed on merit granted. See the findings. On careful case diary, it appears that police has got ample opportunity to interrogate the accused during police remand of 9 days. It is also found that further custody accused at this stage of investigation is not necessary. In this case of the purpose of investigation, as the mobile phones of accused already says and sent to FSL to retrieve data. In view of such seizure of mobile phones and sending the same to FSL to retrieve data, there is no chance of the part accused to hamper with the investigation. They finally decided what is interim.
My lord, that's why we are surprised, my lord. The Home Departments I have communicated later, my lord, after granting interim bail to cancellations of this said interim because departments are surprised, my lord, how this order has been passed. At the same time, my lord, this petitioner bail has been rejected and main kingpin bail was, my lord, granted interim, my lord. That is, my lord, very surprising fact with us, my lord. So we are also, my lord, unhappy with the, my lord.
Make an observation, we'll grant him bail on the basis, not on basis of this order.
My lord.
We are not granting him
But
bail
I'm
on the basis of disorder. We'll see the material that because he's the main kingpin, he was the money handler. Money has already been recovered. He is in custody, therefore we are granting.
That is the material only I have found in the
So
case.
therefore, on that, we will not go for that. He is entitled for bail. We will not give any certificate to this bail order. Or Mr. BD. That is up to the session.
That I was very disturbed initially by this.
Let us not go to that without.
I was very disturbed because we have never indulged in this type of practice.
So this let the learned session just decide on its own merit. We are not nothing to comment. We'll see whenever whatever comes to us. We are not to comment on this.
We are also very much surprising in my lord this type of order is in past by this.
That you have your remedy.
Yes, that's why, my lord, immediately I have been communicated, my lord.
Third, Mr. B.D. Kaur, Learned Senior Counsel, assisted by
H. Agarwal.
H. Agarwal, Learned Counsel, and also heard Mr. Makhan Fukan, Learned Public Prosecutor representing the state. The FIR reveals that on the basis of a report as regards illegal betting and gambling of IPL cricket matches, the Tinsukia police searched certain premises, more particularly premises of one Suprit Biswas, alias Honey Singh, HONNYSING, Honey Singh, and arrested him. On the basis of such, thereafter, on the basis of materials gathered from the arrested accused person, no, full stop. Thereafter, another person, namely Bikas Beria, was arrested, full stop. On the basis of the statement made by the accused Bikas Beria, the petitioner was also arrested and was produced before the Learned Chief Judicial Magistrate Tinsukia on 3/5/2024. Since then, the petitioner is in custody. Full stop. This court, the case diary is produced. Same is perused. The case diary reflects that the main kingpin, is one accused Bikas Beria, and the petitioner herein is the handler of accused Bikas, money handler of accused Bikas Beria. Full stop. It is also seen that certain amount of money were recovered from the house of the accused person. Full stop. Except the aforesaid material, till now, no other specific material is available against the present accused. Full stop. The accused has also been thoroughly interrogated by the investigating officer. Full stop. He has been in custody since 3/5/2023. Considering the period of detention and the materials available on record, this court is of the view that further custodial detention of the petitioners may not be necessary. However, accordingly, the present application is allowed. Full stop. Full stop. It is further made clear that the petitioner shall make himself available for interrogation as and when the investigating officer calls him, including joint interrogation with the accused, other co-accused in this case. Full stop. Accordingly, the present application stands allowed. Full stop. Present application stands allowed with the following conditions. 1 lakh not to leave the jurisdiction without IO's permission, not to influence all.
3/5/24, not 20.
I'm back still.
No, your lordship is forward.
Yes. Yes.
Was called for.
Case diary not received, my lord.
Okay. Case diary not received. Interim to continue. When? Release this matter on?
Release this matter on my 11th of June.
11th of June.
22. Here the same pair, my lord, on interim, my lord.
Interim 2011. Interim to continue.
23, my lord, I require some time, my lord. The CD received, my lord, just now, my lord. So,
Okay.
and other thing is, the
Mr. MP Goswami, Learned Regional Public Prosecutor, submits that though he has received the case diary,
statements are not here, and also
Huh?
his statement is also not here. He's on interim. my lord. He appeared. So I'll take the
Okay.
instruction. We'll-
However, the statement of the statement of the petitioner is not available on record. Full stop. Mr. Das, learned counsel for the petitioner, submits that petitioner has already got his statement recorded. Full stop. Petitioner submits that the IO has already recorded the statement of the petitioner. That being the
Update the CD, my lord, on
that
3rd of
being
June.
the position, Mr. Goswami submits that he may be allowed to return back the CD and get it updated from the IO.
Prevent, my lord.
Full stop.
7th.
Prayer is allowed. List this matter on
7th
7th of June 2024. Interim order pass earlier.
Fine, deeply.
In the if in the meantime, petitioner may once again appear before the IO.
My lord, highly obeyed.
This matter also causative was called for, and I'm an interim. I appeared before the IO lordship.
What is the allegation?
Allegation that lordship, one Muhammad Ali lordship, I'm not Muhammad Ali, I am Din Muhammad Ali. One Muhammad Ali lordship, one Jafar Ali lordship claimed some lordship insurance regarding a dead cow lordship. And for that your lordship,
Mr. Bhattacharya, in a lighter vein, only cattle and cows and bullocks are in the Assam or what? No other thing. Vehicle offenses, vehicle season, the cow, bullock, head, then meat, what not. Now there's certificate.
Lord, since
What is
earlier
this?
regarding for my lord, this procedure of claiming my lord, insurance claim by submitting my lord the PM report of death cow, this was going on since earlier, my lord.
Now who is he?
He is the my lord, one initially police arrested one Jafar Ali.
Mm.
My lord, allegation is that my lord, all this person has my lord, forged this signature, seal and paid up one
The
doctor.
officer who issued the
Yes,
sir.
one of the veterinary, Dr. Nabokanta Sharma. Then, my lord, while one of the my lord insurance inspector asked him that my lord by suspecting his my lord signature, then thereafter my lord entire
was
matter came to light. Then, my lord, during investigation, police initially arrested one Jafar Ali and one Muhammad Ali. The present petitioner is my lord Din Muhammad Ali. Thereafter, my lord, after his arrest, his house was also searched. Then, my lord, from his house, Muhammad Ali's house, my lord, seal signature of Dr. Nabokanta Sharma was also recovered.
Now whether he is involved.
He present person is the person, my lord, who introduced Muhammad Ali by my lord, naming him as a doctor of veterinary to Jafar Ali. Thereafter, my lord, on that belief, Jafar Ali
Okay,
approached
forget about all this. Do
Muhammad.
you require his custodial intervention?
He appeared statement recorded materials is against the present petitioner also, my lord. Because he introduced, falsely introduced Muhammad Ali as doctor, my lord,
Agora to 2 and 3.
to the
Then
FSL report also received, my lord.
Perus the case that is produced. First of same is Perus. It replay to Agor Dimarasal. Dispose. Same terms and conditions.
Item 25, along with item 43.
20.
25 and item number 43. Lordship.
I am for item number 25.
In this case, Lordship, what happened? Lordship?
This is where my
Yes, my lord. I have been informed that CD has been arrived, my lord. So, my lord, can it be taken up next week, any date, my lord?
this we are allowing PA.
Kindly considering to the aspect, Lordship,
because my
So
lord,
far AB interim is there. Is that it?
no, in the meantime, item number 25, Lordship.
25 interim is there. So
During pendency of the interim bill, he was arrested, Lord. This is the main point.
I want to, my lord, just inquire, my lord.
you have it.
Say,
You
so-
not Monday, not Monday.
Today, 2 p.m. Lordship.
Not 2 p.m. Today by before 1.
Yes, sir. That is-
After too difficult because I'm leaving for some
Yes, sir.
official work.
No,
No, he's inside sir. And if this is done, we'll close it and proceed with the
no.
petition.
during
We'll keep it pending this precedent.
Yes,
Now I recall this.
Yes, sir. During pendency of this, the police arrested the petitioner.
He delayed in appearing.
Yes, sir.
There was a delay and after there was an interim order, police arrested him.
In the
So we are not allowing this officer to go,
No, sir.
subject to what is, we'll issue a notice to him, register a suo motu case and call him, and in the meantime we'll grant him bail.
No, sir.
Item 26.
May I please, Your Lordship. My lord, kindly, there is the FIR
Item,
26.
item,
26.
26.
yes.
FIR at page 8, your lordship. Civil dispute is going on between the
My lord,
parties.
I pray, my lord, date may be given, my lord, from, for CD, my lord. Not received.
Okay, when?
On my lord, 31st, my lord.
31st.
Interim prayer may kindly be considered.
We'll
If-
consider on 31st.
If anything found against him, on that day, my lord, interim may be vacated, your lordship. I have no.
We'll do it on, not 31st, if give it is from which police station?
Jalukbari.
Chalukbari, give it on Monday, 27th.
On the last occasion, my lord, last order may kindly be used.
Without fail.
Yes.
We always fail.
I will appear before the IU, your lord.
You wait till Friday, till Monday,
Yes,
Okay.
28, my lord.
28.
28.
Okay?
Yes.
This is an application under section 430.
Yeah, what about? Where is the FIR?
Page
Page
10,
14 one.
page 14.
Yes, what about?
Yes, 177.
Huh?
Gunny bag recovered.
Gunny bag with Burmese betel nut. You'll have to mind the language.
Yes,
It's only suspected, my lord. The petitioner is, my lord, earns his livelihood by selling betel nuts, my lord, local betel nuts, my lord.
We know what is local, what is not disposed of, allowed.
Obliged, my lord.
Yeah, okay, we will consider as materials, cooperated, no further. केवल FIR और हेरिट लिख दियो allegation लिखियो yes 47
47 case diary not received me.
None appears for the petitioner on call. List this matter on
On 7th of June, maybe.
7th of June for production of case diary.
That's legal, lordship.
Yes.
Lordship, 439 application, lordship, and as on today, lordship, and 29 days in custody, lordship. And lordship, section is only 379 is non-valuable, lordship. And FIR will find page number 11, lordship.
Now I was asking, what about that person from whose that 16,000 were recovered? Petrol.
Lordship,
It was required from whom?
And lordship, I am the landlord, lordship, and I'm very specific.
What is your name?
Rafiqul
Islam.
Rafiqul Islam.
Who is the main person in this?
And lordship, kindly come to page number 16, last para number 3, lordship, last serial number 3. During the investigation, it revealed that the name of his co-accused and those whom he sells and illegally produce oil, namely Sojim Alam Ali, Petla, Lalsan, Ziarul, Fulsan, Mannan, and Zilal, lordship. And but lordship, my land is used by them, lordship, on rent basis, lordship. I'm mentioning paragraph number 6, lordship, page number 5, para 6.
What is the material against him? Not a small quantity. How many trucks?
3 trucks.
3 trucks
Only one
fully
instance.
loaded with kerosene oil. 16,000 liter in one truck.
Lordship,
Only
lordship,
one instance, Lordship. There
Huh.
are several instances, Lordship. That's what I was trying to point out, Lordship. Lordship, here he appears to be the main financier who arranges all the link, Lordship. He calls up the driver to drive the vehicles. Then
You have 2 options. We'll adjourn this matter. How many days?
29 days, lordship,
What is the maximum period?
60 days.
10 days more. 10 days more.
And then, lordship, on the,
And you also complete what is the stage of investigation?
Lordship, some more co-accused are there, Lordship, and there are several other instances where the act has been.
what co-accused already granted.
Co-accused, these forget about others.
Lordship.
This is not a case
Can it be
for a time.
31st, lordship?
You can return back the case diary.
Lordship, can it be on 4th?
4th of June. Be there for some time. Be happy there for some time. Yes. 4th of June. For case diary.
Orders, item 28.
Return to Ligima. We press that may be updated. Item. None appears for the. Somebody made a mention, there was a stay order, beyond stay, court has proceeded. None appears for the petitioner on call. Yes.
28, Lordship. Already.
We'll have to invite you or what?
Sorry, Lordship. I was expecting to call the admission 17 and 18, 28, both are analogous matter.
Now you
There was
give
an
another matter, please call it item number
17.
One?
15, sorry, 15.
15. What
And there
happened
are
to
two
15?
other matters are.
So what to do today?
Lordship may adjourn the matter.
Today?
Okay.
Okay.
Along with the
Okay, it is
other-
submitted that two other matters being criminal.
criminal
Trans-
petition number 9.
Transfer petition.
Transfer petition number
10, 20, 10, 24 and 8,
10. Amar Tat-
Just give the numbers of the
I'll
cause
give it.
list. Item number,
Item number.
Here 15 and 24.
we know that.
16 and 17 of
16 and 17 of
21.
court number 21, huh? It is submitted that two other matters, that is so and so number juta dibo. Or give the numbers, cases numbers are also listed today in court number 21. Full stop. Accordingly, it is submitted, the matter may be adjourned today. Full stop, and be directed to be listed along with these two petitions. Prayer is allowed, comma, accordingly, matter stands adjourned, and these matters to be listed along with so and so.
My lord, I am appearing for respondent number 2, my lord. Already, my lord, 2 matters, my lord. Before the court number 21, my lord, already been reached, my lord. I have mentioned, my lord. I was there, my lord.
You mentioned in what?
Mentioned that before your lordship, one matter has been listed.
Now, what is the order passing?
Whatever after a week, my lord. And maybe
Okay,
that
list
to
this
start.
figure, give a date. Give a date. Give a date.
Sorry.
3rd of June.
NBW has already been issued. Can it be a bit earlier? 29.
Okay, give it on Monday.
Monday. Lordship.
Monday.
27.
So Tuesday.
My lord.
If it is correct that even after stay
Yes,
of
sir.
this court,
I can show the order.
if
also.
that court order of this court, then
There is-
will not go it scot-free.
There is an
it's-
observation that the stay order pass was not any speaking order. That much magistrate has.
Let us see this.
I have filed an affidavit, but that is not on record, but I have the certificate
My
copy.
lord, I have not been received furnished my copy, my lord. I have on my instruction.
No, we are not against it.
My lord.
Give this. Who is this officer?
Third paragraph, Lordship, fourth paragraph, Lordship. However, it is to be noted that the said order of stay by the Honorable High Court dated so and so was not done by virtue of speaking order.
Where is paragraph?
Fourth paragraph, Lordship. No, একটু আহানাই না।
Okay, we'll take it up on Tuesday.
Lordship.
When is the next date? Huh?
Yes.
3rd of
June.
June. Okay, we'll take it up on Tuesday. List it along with so and so dilo on such and such that. It is submitted that an additional affidavit has been filed full stocks by the petitioner on
Monday.
they give a date. We cannot write as Monday in the
20,
court's order.
20.
We'll have to give a date. 2005-2020 for registry to verify and take the same along with the record.
In the meantime, my lord, my learned friend will furnish the
Definitely
copy.
will give it. Give it.
Obliged.
Next.
May I please, Your Honor? Your Honor, state has not filed their objection against the IA.
What is this?
Against the conviction.
Appeal has already been admitted.
Yes, Your Honor.
What is the period?
10 years.
10 years, Your Honor.
10 years. Have you filed any IA?
Yes, yes.
What is the IA?
We'd like to file our objection, Lordship.
You want to file an objection? Okay. IA likhibo, huh? Service in respect of respondent number 2 is complete and Mr. F. Khan enters, learned advocate enters appears on a behalf of such respondent. Full stop. Mr. B. Sharma, learned additional public prosecutor, prays for and is granted 10 days further time to file objection in the IA. Full stop. List accordingly after 10 days.
Right, Your Honor.
Yes, F14.
Lord, Mr. Chaudhary is on his legs, my lord. After some time.
What to do today? Almost hearing concluded.
Yes, my lord. Hearing has otherwise concluded.
Anything to be added?
Just two judgments, my lord. We've
Yes. Give the PC. Yes.
With Krishnakant Dattaram Chodankar versus State of Goa, my lord. Relevant paras, my lord, para 18 to 34, my lord.
Paragraph?
18 to 34, my lord.
Okay.
Herein they have discussed this has come after Chandrababu Naidu's case, my lord.
Okay.
So they have discussed Chandrababu Naidu as well as Yashwant Sinha, my lord.
Okay. Okay.
And my lord, Sri Rupa versus State of Karnataka.
Where do you get the exact paragraph? Paragraph
My
18
lord, 18 to 34, my lord.
What is the ratio in which paragraph?
My lord. My lord, para 34, they have, after discussing, they have said that in this matter, no such inquiry into the delayed application or proposal for approval under section 70A is forwarded and obtained from the competent authority. Thus, the investigation which has been initiated by respondent number 2 without approval of 17A is prima facie without any authority or jurisdiction, my lord.
Okay.
And my
Paragraph?
lord, Sri Rupa versus State of Karnataka, my lord.
Paragraph 17 to 34.
This one, my lord, paragraph 21 to 20.
No, this Krishnakant.
My lord, 18 to 34.
18 to
34.
34. Okay.
And
And
my-
this other case?
My lord, paragraph 21 to 28. Here, my lord, they have discussed the necessity of judicial application of mine even in case of passing an order under section 17A.
Okay.
My lord will find that at paragraphs 27 and 28, my lord. There requires an cast an obligation of application of mine on the part of the competent authority.
Paragraph 27.
27 and 28. Here also, my lord, Yashwant Sinha has been discussed, my lord.
No, you have given same judgment twice.
My lord.
This is Datta, the Krishnakanta Dattaram.
Oh, sorry, my lord. Yes.
Here, which paragraph?
Paragraph, my lord, starts from 21 to 28, but relevant will be 27 and 28, my lord.
Okay. Now tell us one thing. You understand everything. Come to paragraphs that judgment that is 7A. What Mr. Chaudhary argued is that yes, the material, the disproportionate asset from the search sheet itself discloses that it has been done during his service from so and so so and so. So therefore, it is relatable to his service, and therefore 7 maybe it's disproportionate. 7A will be required. This is a mandate of law in terms of Jaswanti. This is your argument.
Yes.
Now just read the 7A.
17.
17A.
Inquiry or investigation of offences.
Just go slow, go slow. Okay.
Sorry,
Hmm.
Inquiry.
Mr. Fukan, you also read. Okay.
Inquiry or investigation of offences relatable to recommendations made or decision taken by public
Now,
servants.
just as us, why there is not a full stop inquiry or investigation of offenses, either full stop or relatable to discharge of duty. This could have been clarified the whole position. Legislature has used this word inquiry or investigation of offenses relatable to recommendations made or decision taken. It has been qualified as recommendations made or decision taken by public servant. So what is the object of these recommendations made or decision taken? Is it require a specific instance of recommendation made or decision taken, or every penny illegally acquired from a service can be said to be relatable to a decision made or a recommendation made? Why this word recommendation made and decision taken is used in this script? What is this word used? Why this word is used by the legislature? This would not have been. There could be, see, the language could have been like this. No police officer shall conduct any inquiry or investigation into any offense. Full stop. Under this act. Matter is over. Now it says no offense, no police officer shall conduct any inquiry or investigation into any offense. What is the qualification? Alleged to have been committed by a public servant under this act. Okay. Matter would have been full stop here. There is a qualification where the alleged offense is relatable to any recommendation made or decision taken by public servant.
On the last day, the learned PT was giving an illustration, my lord. Actually, the person is desirous of getting a job or is desirous of getting a promotion. Now, that act of promoting the person or transferring the person can only be pursuant to a decision taken by the public servant, or it can be pursuant to a recommendation.
No, Mr. Chaudhary has answered it. Mr. Chaudhary has replied it that, see, your allegation is that I have taken money from decision of transfer. Okay. Now, that is fine. That is a acceptable argument. Because purpose is to protect a person from officer from the unnecessary inquiry and investigation. The object is clear. Anybody will come and file an application, the officer should not be harassed. But the legislature has used this word relatable to any recommendation made, and that is where we are a little bit.
Because it is not an unqualified requirement.
Not unqualified.
Qualification is there that it has to.
And no judgment has dealt with this portion. Not a single judgment, no, even Jaswant Singh. Jaswant Singh says it will be required when it quotes the section.
Okay.
Why this word relatable and why this word has been used? One kind thing is that whatever uses word, when it is a money, admittedly the allegation is that money gathered during using his service. that is there in the FIR, then it will be required.
Yes.
And other view is that, yes, it should be, it's qualified, it's relatable to a specific offense, specific action. When it is omnibus or vague, it will not be. It should be a specific, and their argument is, this is because so that the officers, upright officers get a handle to take concrete decision and make recommendation. Only for that purpose, not for other purpose. You will take, you will make corruptions and everywhere will require it. This is their argument. Okay. Heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. S. Nawaz, Learned Counsel. Also heard Mr. M. Phukan, Learned Counsel for the Learned Public Prosecutor, a special public prosecutor, agot judicial, CM's Vigilance, and assisted by Mr. P. Datta, Assistant Assistant Special PP, CM's Vigilance. Hearing concluded, judgment reserved. You expect it by Monday because you have urgency. Yes. Lagi. We have concluded.
Well,
See what we'll think over.
well, and I think we have made our.
Yes,
argument.
yes, yeah.
And we have submitted our written submission.
Written
also.
submission also, and we summarize whatever both sides argument just to clarify whether I have rightly understood.
Interesting point, my lord.
Yes, interesting point.
Deeply.
Yes. And no specific judgment on this. Yes, it is. It says that it is applicable, but whether there is any qualification or it's
Or it's
absolute
unqualified.
unqualified. That has not been answered anywhere.
Yes. And I think, my lord.
Even in that day, judgment they are relying
that
on.
Kerala High Court judgment,
Ah.
which they are relying,
Hmm.
and which the coordinate bench of our High Court has also relied upon. That is again, my lord, contra to the
No,
observation of
that's why
Aniruddha Bose.
that's why I'm saying the word used relatable to recommendation
What is
and-
the exact meaning of it?
and decision that has not been dealt. Kerala says it is akin to 176.
197.
197. Kerala says this. Madras High Court simply says it cannot be. Why it cannot be is nothing.
But my lord, lordship will also keep note of one aspect. In Delhi Police Establishment Act, Section 6A was there. That was struck down. Thereafter,
But
this section
this
was
proposition
introduced.
is-
And prima facie, my lord, if we go by the Yaswant Sinha's case, which Supreme Court has rendered again, it says it is mandatory.
It's mandatory, but it says quote unquote the section. It
And
says
my lord,
it's mandatory. So this is where we are just thinking over.
possibly, my lord, that reference will clarify all these points.
Reference might clarify.
Clarify all these points.
Now we expecting while this court has in detail while clarify all these things.
Anyway, my lord.
Okay.
First then item 30. Now item 25.
Yes, Mr. Datta.
My lord,
How much time will you take?
I'll take, my lord, 15 minutes, my lord. Lordship, may kindly see your lordship's order, mother, or the last order.
Oh, this case, we are fixing it some other day. We want your assistance in this case.
I am been engaged in this.
You are engaged in this case. Okay.
Well, PP will be required, my lord, my lord.
PP, Mr. Phukan. This is the case. Acha, this case, heard Mr. NJ Dotto at some length. Full stop. What is your other matters?
এখন তোমার
Mr. Phukan, that I have just morning I told you na, that regarding SOP.
SOP, yes.
SOP. Full stop. Mr. MP Goswami, learned additional public prosecutor submits that learned public prosecutor Mr. M. Phukan will address this court on the issues that has been raised in this case. Full stop. Accordingly, matter stands adjourned for today and be listed on.
Well, at least 1 week, moreover, my lord, what happened? The government of Assam also, home and political departments have made party in this case. Let me issue notice, we'll take instruction from in meantime.
8 respondents are there.
My lord, yes, in item
Notice is
number.
not issued yet.
In new matter, my lord.
Huh?
In my new matter, my lord.
This is the new matter.
Item number 45, man.
This is what we are taking.
Same subject.
Same
Yes,
subject.
yes, yes.
Subject
How
matter
will
is
we
same.
come to that? We'll
Okay,
issue
okay.
that notice in that case.
Ah.
List this matter on
My lord, হপ্তাত বহুত pressure আছে। June, no? 6th on June, my lord. But in meantime, my lord, I have collected all the my lord resources from the government, my lord.
6th.
Because my lord, I have lots of pressure next week. my lord.
No, no, let him have it because we'll have an authority.
Yes, the lordship, the point which was raised by the very much correct matter. SOP cannot override this here, this is true. But under what circumstances they pass an order, at least we need some instruction from the well, governments.
Well, here my submission will be in two tier, my lord. First of all, my clients, my lord, the petitioner before your lordship doesn't come under 321, my lord. And so for 321, my lord, I will address separately, my lord.
Okay.
There are two-
So, but since we want your assistance, we are keeping this for the
yes,
time
yes,
being along with
yes.
the other matters.
My lord,
Okay.
I have given one list of books, my lord.
Okay.
My lord, Asset Pasal.
At least we can also go through it, my lord, because High Court rule says,
Release this matter on 8th of June 2024 as part heard.
my lord.
Registry to reflect name of Mr. M. Phukan, learned PP in this case.
And in his case, my lord, the same subject matters, my lord.
Okay, then we are issuing a notice.
My lord, yes. In meantime, my lord, the state government was also party, my lord. We have received.
That may not be
Some,
taken.
it may so happen that the question, Mr. Datta may say tomorrow that this is not in fact a important issue. This is settled.
Yes.
He may say that also. For us, this is an issue.
Also, that matter may not be tagged, my lord.
Huh?
That 45 may not be tagged, my lord.
No, will not take.
That's my submission.
No, my lord, it is necessary, my lord.
No, not necessary. I'm not expecting it necessary now.
Let me submit, my lord.
Okay, where is your item?
My lord, kindly see, my lord.
Heard Mr. A. M. Borvuya, learned counsel for the petitioner. The present, this is 45. The present application under section 482 of CRPC, read with section 397 of the 482, read with section 397 of the Code of Criminal Procedure is filed with a prayer to set aside and quash and order dated 1/6/2023 passed by the learned Munsif number 1, Magistrate First Class Hailakandi in GR case number 929/2016.
And SOP also, my lord.
Huh?
SOP also I am telling, my lord.
Full stop. Full stop. Whereby on withdrawal of the GR case by the state, the petitioner was directed to
File, my lord.
file a CR case. Is not it? Full stop. The petitioner further challenges then, but where 482 we have challenged SOP, okay? It should have been file a writ petition here. That
Yes.
would have been
In
the
division
best thing.
bench.
Yes.
No, no, I am saying, my lord, both the case may be. taken, my lord.
Maybe in the other case also, that order can also be challenged in 226.
Yes,
There
yes,
is
ma'am.
no problem on that. Anyway, all further challenges made is standard operating procedure dated 21/10/2022 issued by the Undersecretary to the Government of Assam Judicial Department dispute
Sure, Nandan.
on the ground that under the scheme of the Code of Criminal Procedure, no such SOP can be issued. Full stop. This matter needs further detail in consideration. Accordingly, issue notice returnable on 8th of June. Returnable on 8th of June. Mr. Phukan Mr. MP Goswami accepts notice on behalf of the respondent number 1. Mr. D. Nath, is he available in?
My lord, record his name, my lord.
Okay.
Photo I sent.
Huh?
He is available.
Available. Mr. D. Nath, learned senior government advocate, accepts notice on behalf of respondent number 2 and 3. Full stop. Respondent number 2 and 3. Therefore, no formal notice need be issued to the said respondents. However, extra copies be furnished, requisite in numbers, be furnished. Full stop. The petitioner to take steps upon respondent number 4, 5, 6, 7, and 8 by registered post as well as usual process. Notice is returnable after 4 is divided. 10th of after 4 weeks added. 25/6.
And moreover, my lord, the registry may direct to reflect the name of the Dinath as a GA Assam in the
Okay.
cause list.
Our registry to reflect the name of Mr. D. Nath, learned senior government advocate, and Mr. We'll say M. Phukan accepts notice.
Dinath, a GA Assam should be necessary. Otherwise, he
GA Assam and Mr. M. Phukan, learned deputy in the cause list.
much of that.
Well, I think Lordship is rising today early.
We have some official
Yes, but
program
there-
leaving
yes,
for
my lord, I have heard that.
Shivsagar.
Well, one item is there, well, item 40, it's also part heard, my lord.
Ah.
And in that case also, my lord, I think, my lord, my PP shall appear.
Item?
Item 40, it will, if 40 the. 40.
40.
It NDPS.
Oh, that important. That
Yeah,
he has
very-
raised certain issues which might have a far-reaching
that's
consequences.
right.
He is raising an issue to an extent that these drugs in bottle, this cough syrups and all, will not come on within the meaning of narcotic. It will come under the Drugs and Cosmetic Act. Whatsoever the quantity, you can seize it, do whatever you like under that there no criminality can be attributed here. He is relying on two judgments of other high courts, whether that is that will be only a not binding precedent, but it will have a persuasive value. So how can that pursue us will also depend upon how Mr. PP argues.
That's it.
Okay, and anything on that point in Supreme Court?
Yes.
Huh?
Supreme Court, that has not reached.
No,
But
if that has there may be some decision against this also.
my lord.
We need to be careful because
Yes.
the
Far-reaching effect, my lord.
it will have a serious consequences.
My lord, so far I remember, my lord, this question was raised in earlier occasion also, my lord, in chief courts, my lord, court number 1.
That was raised
Mm.
and it was dealt by the Supreme Court, but that too, but it is in a bail matter. That case came.
No,
went
even
from
if
one-
it is bail
Bail
matter,
matter,
what
yeah.
is the
The issue was discussed.
anything has been observed or decided, we'll go through it. Okay, since somebody has raised an argument, we cannot say that don't argue.
Yes,
We'll have to answer it.
yes.
Our job is to answer. And we'll not hesitate to answer anything.
Well, absolutely.
Yes.
It may be fixed.
Come on.
Additional liquidation data.
Some length
সোনকালে লতা
due
মানে
to
মই
paucity of time, matter could
এই
not be
ওলাব লাগে।
concluded.
13 June, no? অলপ পক হবে, no?
List this matter for further hearing on
13, my lord, 13 June,
13th of June.
1-3. হ'ব দিয়ক, তাৰমানে বহুত পইচা।
Yes. My lord, one more thing, my lord, item number 30,
সেইটো
that
part-
interim order shall continue.
important
Which?
Item 30, my lord. That was
Okay,
state, my lord.
okay, interim order pass earlier.
And my name may be reflected, my lord.
And also registry to reflect the name of Mr. Anjerath. Your juniors are there, why should you go through the public?
My lord, they went to the home, my lord. Sometimes.
Don't appear with this kind of juniors. Yes, next case.
I'm obliged, my lord.
No. Sis. Item 31, 32, 33. Mr. P. Datta, learned special PP vigilance submits that he may be granted 2 days time to take steps. Full stop. To steps upon the sole respondent. Prayer is allowed. List accordingly after 4 weeks. Take the steps.
Yes.
Why you forget to take steps? Yes. Where is the other side?
The Lordship. Okay, coming, I think so, he was there, Lordship.
Who is the other side? Cal.
So Mr. D. Sekiala, Mr. P. Gogoi. Lordship, in this case, we have challenged the order of assessment only on the grounds that no reasonable opportunity has been granted to me.
Okay, what is the provision of notice?
Lordship, the notice, Lordship, Lordship may kindly see. Lordship, this is section 37 which they have issued. Rule 25, Lordship, of the Assam Value Added Tax Act rules.
Value added tax. We do not know in a criminal bench whether value added tax will be there. Show us your notice first.
Lordship, I will I will pass on the book.
Okay.
But first, I will, Lordship, in the additional affidavit which I have filed, Lordship, I have annexed the entire thing.
Okay.
Additional affidavit, Lordship, may kindly see. Annexure A.
Annexure A.
A.
Okay, this was a show cause notice under 9 of the CST.
CST read with section 37.
37 of the Assam.
CST contains only 10 to 11 sections. They have adopted the respective states. They have adopted Assam VAT Act.
Okay.
All provisions.
Okay.
Whatever assessment, everything is done under CST. Assessment is done under VAT. So section
So under section 9, it
says that I adopt section
okay,
37, everything.
fine. Okay.
So, Lordship, so
this is the show cause notice.
This is the so-called notice. This was issued to me on 18th of December 2014, Lordship.
Okay, let us see.
Lordship, Lordship may kindly see in the left received date. Lordship, this is a practice, the regular practice in sales tax department. Whenever they serve me a so-called notice, they, Lordship, write the date of receipt. Lordship, that is why in the left-hand corner, Lordship, on
23/12/14. Then
that day I have received. Now they have asked me to appear to show cause, Lordship, against this notice on 29th, Lordship.
extension of time is at page 59.
Yes, Your Lordship.
So
Lordship,
on
I asked for extension of time, they have rejected. I asked that to 20, that is the amount.
your what was the date to notice was issued on
18 December.
18 December. Forget about the timing. What is the time granted to file reply?
Lordship, that is the 28th of Lordship, 28th.
Where is that? Explain
29th,
the
Lordship.
matter
Page
with evidence to show cause appearing personally through an authorized agent on or before 29/12.
Lordship.
So you file an application on 29.
Yes, Your
Okay,
Lordship.
so they say that by 6th of January, they say that
I cannot, I reject your application
rejected
and I will pass and they pass the order of assessment on 12th.
now what is your prayer? You want to go back?
Lordship, I want to go back. I want a reasonable opportunity of being heard.
Yes, Mr. Gogoi, only that limited.
Lordship,
That part I leave it to your lordship.
No, don't leave it to us. If it is C, all things cannot be left to us because suppose there is a absolute bar. Okay, we can exercise our power. We are not saying it.
Yes.
Just show us the law whether we can give it, grant it. See, apparently it seems that 29 they have filed the application.
If that opportunity, had that opportunity been given to them, they could have submitted corrected copies of the C form. Our affidavit, we have placed, my lord, that the dealers with whom the petitioner alleges that they have made some transaction, they have said that they have not issued any such C forms.
So
So it's the other disputed part. If they can produce, my lord, then lordship will revert it back within a time frame. Let them decide.
Within a time frame.
Yes, there should be a time frame because from 15.
it is exempted anyhow. I did not produce the
No, whatever-
C form.
But that we are not commenting anything. We will only go that this notice.
Yes, Your Lordship.
Huh?
Lordship,
Notice?
only notice and assessment order may go, Lordship, and they may
They will do a fresh.
Lordship.
They will do a fresh.
Lordship, I will, Lordship, just place one judgment
Yes,
of this
yes.
division bench of this honorable court exactly on the same point.
Okay,
Exact
that
same.
will help us.
Yes, Your Lordship. This is Dwijendra Kumar Bhattacharya, Lordship, paragraph 13.
You put it in focus.
ये दे दो, copy दे दो. 13, Lordship, paragraph 13. The division bench judgment, Lordship. Paragraph 13 says, at this stage, may I read, Lordship? It may be pertinent to emphasize that opportunity of hearing to the SSC contemplated above is not an empty formality or ritual or pretense. It is a valuable right granted to the SSC and in fact is an important safeguard against arbitrary assessments. It cannot be taken lightly by the authorities. Opportunity must be real and reasonable. If an associate who is asked to furnish certain particulars or submit explanation within a specified time
prays for further time, stating his difficulties and or reasons, his prayer should not be considered
Where is your
judicious.
application for seeking time?
Lordship, this rejection order is only there with me. The application is rejected. Sometimes
Anything on record?
No, madam.
No. You have rejected, that is there,
That
but
part is there.
that part is there. Anything?
Lordship, sometimes as in the present case, hearings for assessment for a number of years are taken up together, and the SSC is asked to appear and produce evidence in support of his returns. On consideration of the evidence produced by the SSC, the assessing officer might require some further particulars and or informations, which it might not be possible for the SSC to submit instantly or at short notice. He may require reasonable time to furnish the same and
Hard.
pay for the same.
That
before
part,
the
my lord,
date
if they are going on merit, my lord,
No,
then
no,
I
we
will.
are not going on merit. We are simply say
Going.
that
Yes,
they have filed an application and that has been rejected without assigning any reason, simply saying that they have rejected. Therefore,
Only
we'll
on the rejection.
only on the, no, not
Only
merit.
the rejection, Lord.
Because, my lord,
I will
only on
not
the
appeal
why
for
I'm
a single
saying, no, no,
time
no,
on merit.
I understand that part, my lord, lordship may kindly see the order of rejection for a moment, so that that part may not be tough. Page 36,
No, that we are saying about page 59,
my lord.
Additional affidavit.
additional affidavit. Admittedly, it was up by 29th by the notice. And it says references your letter dated 29/12. So meaning thereby they sought an extension on 29th. It's not that they did not appear on 29th. Kindly see your letter nil dated 29/12. Okay, so we are not going for anything. It says we are in receive letter above, but you have already availed so
That
much of time.
extension time was rejected.
Extension time. So it is not said, yeah, here the ground is that you have already availed so much of time. There is no scope of availing so much of time because it was on reply was to be made on.
My lord, one line that, my lord, that on the merit is honorable.
No, we'll clarify that on the merit of assessment, we are not only for the reason that reasonable opportunity was not granted, we are interpreting with the assessment and rest and nothing should be meant for the merit. Simply, we'll even clarify up one paragraph.
And only one opportunity may be given.
One
to them
will
so
fix
that-
a date. They will say a date on which
Yes,
they
yes.
will file the reply.
Yes, ma'am.
And we'll ask them to appear on that day. Give a
We'll give
prepare.
a reasonable opportunity of hearing. Lordship, whatever papers and documents they require. Lordship, nowadays, Lordship, the sales tax authorities are very.
No, no, we do not know anything. You tell us on which date will you file this objection, assessment.
Kindly give me 1 month's time.
Give a date. We'll give a date.
Yes, Lordship. They will give a notice and we'll appear within 1 month.
No, earlier notice will remain. It will be treated as the earlier, no fresh
As on
notice.
the date when the order was passed, from that day the proceeding will continue. But at this stage.
See, notice was given on 18th of December 2014. You will have to make a reply to the notice of 18/4 by the next 1 month.
Yes.
On or before, we'll give a such a
Yes,
date.
your lordship. Yes,
And
your
on the filing of that, they will
your
complete the process after hearing whatever by following the due process of law.
Due
That's
process,
all.
my lord.
That's all. Hard. And Havelia Learned Counsel for the petitioner. Also heard Mr. B. Gogoi, Learned Standing Counsel for the Finance and Taxation Department, State of Assam. The present application under Article 226 of the Constitution of India is filed assailing an order of assessment dated 12/1/2015 passed by the Superintendent of Taxes, Central VAT Audit Team, Guwahati, Assam. Full stop. Though the aforesaid assessment order has been challenged in the present writ petition on various grounds. However, the Learned Counsel MS N. Havelia has confined her argument to only the point that such assessment order has been passed without giving due opportunity of hearing. Full stop. In this context, see, referring to no, full stop. In this context, referring to the notice dated, where is the notice? Page
Lordship, in the additional affidavit, Lordship. 18/12/2014.
referring to the notice dated
18/12/2014.
18/12/2014 issued under Section 37 of the Assam Value-Added Tax Act 2003, the Learned Council submits that by the aforesaid notice, the petitioner was asked to explain and to show cause by 29/12/2014 as to why the assessment for the period 2009/2010 to 2010-2011, 2011-2012 and 2012 to 2013 shall not be completed, isn't it? Completed on the basis of facts and sales considered as detailed in the said notice. Full stop. Thereafter, it is seen from the record that on 29/12/2014, the Superintendent of Taxes, Central on 29/12/2014, the petitioner made an application before the Superintendent of Taxes, Central VAT audit team requesting extension of time to submit reply. However, such prayer was rejected by an order dated 6th of January 2015 on the ground that the petitioner had already availed time and therefore no extension of time can be granted. And accordingly, the matter proceeded ex parte and the impugn assessment was done. Full stop. Impugn assessment was done. Accordingly, MS Havelia Learned Council submits that the impugn assessment order has been filed violating the petitioners violating the principles of natural justice, in as much as assessee is entitled for reasonable time to reply to such so-called notice, more particularly when the assessment relates to a very long period. Full stop. Accordingly, she submits that the assessment is liable to be set aside and quashed on the ground of being violative of principles of natural justice. Full stop. Per contra, Mr. B. Gogoi, Learned Council submits that several opportunities were given, and in spite of such opportunities, the petitioner had failed to reply to such assessment, and therefore there is no wrong in proceeding ex parte against the petitioner.
Reply to the so-called notice.
A reply to the so-called notice. Accordingly, there is no fault can be attributed to the Superintendent of Taxes Central VAT Audit Team in proceeding in the matter ex parte and passing the impugn order. First of all, I have given anxious considerations to the arguments advanced by the Learned Council for the parties. We'll do one thing, you will get it the order on Monday.
Yeah.
Now, please give the notices same, all same.
Dates will be different, I will give the dates.
So every matter, date of notice and order of the rejection, order of the rejection, and your seeking time, date of your seeking time. You give that, then we'll do it, get till Monday. So in view of the opposite, the assessment or impugn assessment order is set aside, being violative of the principles of natural justice. Full stop. The petitioner now is relegated to the officer Kolu, Superintendent of Taxes, so and so, full stop. Subject to the condition that the petitioner shall file the objection on
24th
objection to the so-called notice dated. In every case, it will be different. So-called notice dated so and so,
24th July.
On or before 24th of July 20.
No, Within 1 month, my lord.
1 month.
We are in May, my lord. It cannot be
May,
after
May,
2
we are in
months.
May.
Oh.
May, within 1 month, not beyond that.
No, even then, my lord.
From today's May is what month? Huh? Huh? 24th of June. 24th of June on or before 24th of June 2024. Full stop. 24th of June 2024. Full stop. It is further made clear that in the event such objection is not filed,
Then, my lord, the earlier or assessment order as well as the
thus earlier order of assessment,
will revive.
impugn order of assessment dated, give the date, shall automatically revive. Full stop. Revive. This court expects that the authorities shall dispose of the matter as expeditiously possible, inasmuch as this matter pertains to an assessment of the year starting from the 2010-11. Full stop. While parting with the record, it is made clear that this court has not commented anything on the merit of the claim of the SSC or the tax department, and the superintendent of so shall decide the matter in the event and so cause reply is filed on its own merit without being influenced by any of the observation made in this case. All disposed of. Up to, but subject to, this will be uploaded subject to your furnishing in
I will
details. Huh?
Furnish all the details.
All these are required. And don't come later on that there is a mistake, correct it, we will not correct it.
So furnish the entire details of dates and officer. Lordship. Lordship, only one observation, Lordship. I said reasonable opportunity. It was written due opportunity. When my submission is given, that
the time now.
We have given the time, that is the reasonable.
no, Lordship, my submission.
Okay,
when-
that will reject it.
My submission. Much obliged.
Yes, what is this?
Matter pertains to dishonor of the chief, Lordship. Lordship, I may be allowed some reasonable time to make the payment, Your Lordship.
How much?
Tentatively, Lordship, 3 to 4 months.
Huh?
3 to 4 months, Your Lordship.
3 to 4 months.
Let us fix it there after
We'll fix-
1 month, 1 month.
When can you give it?
After 1 month, it will be possible, Lordship.
After 1 month, we are fixing it after 45 days.
My lord.
Okay,
Yes, my lord.
we are giving you 15 days more.
Lordship may record his system.
Record. Learned counsel for the petitioner on instruction from his client submits that the petitioner is willing to honor the due, which is subject matter of the present.
Lordship, sorry to interrupt. We'll make the payment in 3 installments.
Okay, so is ready to make the payment to the respondent number
2, my lord.
to the respondent number 2 within a period of 1 month with 3 installments. Full stop. Accordingly, he seeks for an adjournment. The learned counsel for the respondent submits that if the petitioner pays the amount due to his client, he will not object to such a proposal and will not object the prayer of adjournment in that background. Full stop. Accordingly, the prayer is allowed. Lease this matter on after 45 days. 15th of July 2024. Full stop. On that day, both the learned counsel shall obtain instruction as regard the payment. Full stop. List accordingly.
Hello. In my lord.
What is the case there is?
Injury I have received now. Just
Why he has been arrested?
My
Is
lord,
it not his responsibility to seek and clarification?
Yes, my
At
lord,
least from the PP that he has given an order, what should I do? Should I arrest him?
Yes, the text I am just placing, my lord. Some issues are there, my lord.
No, there may be many issues.
Yes.
We are not saying
Yes.
that there will not be issues.
Yes, yes.
But what is our concern
Yes,
is
sir.
there is an interim order.
Yes, sir.
He
Only
could
that
not-
much I.
Could not appear on
Yes.
such and such date.
Yes, yes.
Will it automatically, without seeking a minimum clarification, we would have believed that you have said that, okay, since he has failed, arrest it. We would have excused him because this is an opinion from a lawyer.
Yes.
that we can debate.
Yes.
But is he an authority to decide, no, this
No,
is.
that is what I am just deliberating, my lord.
Oh.
In my lord, the order was passed on 22/4, my lord. And after that, my lord, within 2/5, he has to appear, my lord. As per the honorable court's order, my lord. Within 22/4.
22 to
Four.
2024.
My lord.
Okay.
And within, so after 10 days, the time is given, my lord. So within 2/5/24, he has to appear, my lord.
Okay.
So after that, my lord, before that also, within 34, he has to appear as per 41A notice. That is.
No, just tell me when interim order was passed.
Interim order passed on 22/4.
22/4/2024.
24, my lord.
Now,
my lord, 2/5, he has to appear. So
2/5, where is that?
Within 10 days, my lord. That is in page 18, your lordship will find first condition, my lord.
Within 10 days.
Within 10 days, my lord.
Okay.
Now, after that, my lord, since, my lord, he has not appeared. So, my lord, the police of, my lord, Dhokwa Khana PS and also.
When he was arrested?
18, my lord. And the police of, my lord, the Dhokwa Khana PS and also the North Lakhimpur, everyone is searching for him, my lord. So the person was apprehended by the OC of, my lord, the Lakhimpur PS, my lord. Thereafter, my lord, he was contacted. And when the IO of this, my lord, police station, he approached that area, my lord, and took charge of him. And thereafter, since he was apprehended, my lord, he was produced before the magistrate, my lord. Now comes the, my lord, the magistrate's order, which is your lordship has to look upon, my lord. So, my lord, there has to be some deliberation, my lord. I could not, my lord, specifically, my lord, whether the IO is at fault or not, my lord.
Kindly come to the page number 18, lordships. Kindly come to the page number 18.
Page 18 of
paragraph number 6
of
the my
BA or AB?
lordship.
Yes.
Page number 18, lordship. Paragraph number 6, lordships. May I read, lordship?
Yes.
Considering the nature of allegation made in the FIR and having regard to the projection made on behalf of the petitioner, it is provided in the interim and till further consideration is made on the basis of the materials in the case diary to be produced, that in the event of arrest, petitioner's connection with Dhokwa Khana PS case number shall be released on bail, lordships. The court is clarified, lordships. Till
But
production of
subject to the condition anyway,
Yes,
will come
subject to
subject
the
to the
condition.
condition.
Yes, subject to I have to tell you. I have explained, lordships.
Hard.
Subject.
Mr. P. Datta, these two applications, the present application is filed under so and so in connection with so and so so and so. The petitioner apprehending arrest in connection with Dhokwa Khana police station case approached this court by way of filing AB 1038/2024. Full stop. AB 2024. This court, under its order dated 22/04/2024, passed an this court passed an interim order under this court order. This court passed an interim order on 22/04/2024 in the aforesaid AB 1038/2024. Whereby interim protection was granted to the petitioner. The relevant portion of the aforesaid order is quoted herein below, paragraph 6. দি তাতে মই এইটো AB2 পৰা চাবা মই এটা লাইন দিছো in the interim pencil mark disu until the consideration is made on the basis of materials in the case diary to be produced should be bold aru order to tolot likhi dibo emphasize supplied by this code. Okay, stop. It is the case of the petitioner that the petitioner could not appear before the IO within a period of 10 days. For the reason, where is that paragraph?
Paragraph number 4, page number 3. Paragraph number 4, page number 3.
Paragraph number 4, page number 3. Could not appear as he was suffering from chicken pox from the last week of April. Full stop. Full stop. The matter was fixed today, isn't it?
Yes.
Matter was comma. This court under its order dated
Page number 17.
order dated 20/04/2024 fixed the matter today for production of case diary. Full stop. Case diary is produced.
Case diary is produced, ma'am.
Full stop. The case diary is also produced. Thus, it is clear that the IO was duly intimated regarding the order of the present case. Full stop. However, on
as subject to my that inference, my lord, whether can be done because
we'll call everything when you have sent the message.
Only the messages were sent calling up the CD, my lord. Whether in time is granted or
So
anything,
if you are doing that, we'll get hold of the PP office also.
because in a wireless message it is been
Maybe how will they know?
because
Because we need not only for this case,
Yes, yes,
we
yes.
need is from some other purposes.
Yes,
Now
yes.
we are proposing
Yes,
to
that is
make certain corrections in the form
yes, yes.
where you will have to give the number PPs any number of the PP office,
Yes.
which will presume that if the order of interim order is gone to that WhatsApp
Yes,
number,
that
it will
everything
be presumed to be the knowledge of the IO.
Yes, yes, that part, but what is present, my lord, and also, my lord, as per paragraph 4, my lord, since he has not appeared, whether he has made any communication to the IO that he
No,
is
thereafter,
suffering
when
from
have you
IO.
intimated him that,
Yes,
where is that paragraph? No, we are not on your knowledge. Where is your paragraph?
Anything in the, my lord, nothing.
That when at the time of arrest you have asked me a copy. Where is that?
Paragraph number 6.
Full stop.
No,
Okay,
what
forget
I'm
about
saying, my lord, he has not appeared till, my lord.
Well, just listen to us. Just listen to us. See, Mr. Goswami,
Yes.
don't protect this
No, no,
officer.
I am not protecting. my
Don't
lord.
protect this officer
am-
because why I'm saying is when he arrested
Yes,
the
yes.
person on which date?
No, I am not protecting, I'm just placing, my lord, subject
No,
to a
just understand. What was the date of arrest?
18/5, my lord,
18/5.
Yes.
When the date was fixed in this case? 22/5.
22/5, today is my lord.
Then he cannot wait for 2 days to produce. We'll take action against not only this. We'll ask call from this magistrate also.
Yes, my lord.
Where is your application that you have filed intimated the magistrate?
Yes, Lordship, that is the
At least, my lord.
page number 23, Lordship.
No, we are keeping the anticipatory bill
Yes, yes,
alive.
that will be alive.
We are granting this bail,
Yes,
bail,
yes.
and we are keeping that alive.
That is
We'll
what I,
give you chance. No,
that
no
is what
worry.
I propose, my lord.
Huh. No, that will give.
Yes.
How can we pass an order against a person without hearing him? We'll not
Yes.
do that.
Yes.
Never.
Page number
He might have good reasons to see.
And also, my lord, regarding the materials in the CD, that has also, I will submit, my lord.
Page number 23, Lordship.
We'll not go into that. We are granting him bail.
Yeah,
BA.
no,
BA.
today,
BA we are granting.
whether,
This has become infectious and we are granting bail for.
whether, my lord, interim bail or, my lord, that, I pray that interim bail in the BA may be granted. Because, my lord, subject to consideration of the CD, that has order has been passed, my lord.
Court ছিল কি করলো? না লাগে headline লাগে. It is produced today. Full stop. Full stop. You see that the IO is aware of pendency of this case. We are not saying interim order, pendency of this case. Full stop. However, on 18/5/2024, the petitioner was arrested and was produced before the learned
SDGM, my lord.
learned SDGM
Within bracket M.
within bracket M
Thokwakhana.
Thokwakhana.
Under the inside of present.
Full stop. A specific statement is made in the bail application that at the time of arrest, the petitioner produced the copy of order dated 22/4/2024 passed in AB number 1038/2024. But the investigating officer has ignored the certified copy and stated that he has the full power to arrest him. Accordingly, the petitioner was arrested and and was produced before the Swenso to agad dile etu pisar dibo. Full stop. Full stop. The case diary produced is perused.
Yes, have been on negligence.
Considering the material collected and also considering consider the same. This court is of the view that petitioner has made out a case for grant of bail. Accordingly, this present bail application stands allowed. Swenso. Then Mr. MP Goswami, learned additional public prosecutor, has submitted that the petitioner is kingpin in a financial scam. Therefore, he should not be granted any bail. Full stop. Consider the above submission. Also peruse the case diary. Full stop. On perusal of the case diary, this court is, after perusal of the case diary, this court is of the view that the IO of the case, in spite of existence of an interim order, has arrested the petitioner, which shall be dealt in the connected AB separately. Full stop. Which should be dealt in the connected separately. After perusal of the material, this court is of the view that no further custodial interrogation of the petitioner is necessary. Accordingly, same stance allowed. Okay. Full stop. This court is also surprised to note that where is your application, bail application?
Bail application, page number 23, Lord. Page number 23.
23.
Findings of the learned trial court, page number 24, Lord.
I was beleg order decided.
Okay, we'll deal it in administrative side. All allowed to the satisfaction of SDGM. Now come to this AB. Agor jekini paragraph dilu. Thereafter, he was arrested and produced before the SDGM. It is specific in the connect. It is specifically stated. That's Swenso. Agor jekini asil talage thakil. Pishat perus CDTD agot hobo. After considering the relevant case diary, which is produced along with the BA so. And conduct of the IO as alleged leads to a prima facie view that the concerned IO has willfully and deliberately violated an order of this court. Full stop. His conduct also shows that he has shown undue haste in arresting the petitioner. Full stop. The case diary was called for by this court under its order dated 24/4/2024, fixing the next date on 22/5/2024. Full stop. And the accused has been arrested on 18th of May 2024, and a specific statement has been made in the connected case, in the connected BA, that the certified copy was shown to the concerned IO and he ignored such order and stated that he has all power to arrest this accused. First of all, in view of the aforesaid of the finding, let a suo motu contempt petition be registered against the IO, namely, give the details. We'll pass this order on Monday.
My lord, what the facts is, my lord, what said, my lord, he has not apprehended him, my lord, the IO, my lord.
But he's the main, whoever apprehends, can a person be, who will produce?
That because he has
That was his responsibility. Even the OC will be responsible.
Yes, my lord. And another thing, my lord, no intimation has been given to the, my lord, IO that we cannot appear within 10 days. So
that will see later on.
And my lord,
that will see later on.
And another aspect, my lord, when he was produced before the magistrate, my lord, Lordship, kindly just for your lordship.
Which magistrate's order?
Yes, my lord.
I have read it.
In the instant hand, my lord, it appears that accused has violated the condition in the Guwahati High Court order, my lord.
Okay, we'll deal with everything. That's why you have registered suo motu. Okay, let the registry register a suo motu contempt petition against the IO of so and so coach, namely, give the details particular by day after tomorrow.
In the forwarding, it can.
Where is that name? Namely, you give details. We don't want to make mistake.
No,
namely, so and so, and list this AB along with the aforesaid application. This anticipatory bail application is, though has become infrastructure, is not closed for the time being. Full stop. The petitioner is Mr. P. Datta, learned counsel for the petitioner, submits that he may be granted to file an additional affidavit bringing on record all the facts according to whom all the facts as regards information given to the IO of existence of the order dated 24/4/2024, and also to incorporate any relevant material in this regard. Prayer is allowed. Please this matter accordingly registry to issue notice to so and so returnable on after 4 weeks.
I'll give the name, man.
This order will correct and pass on a Friday or Monday. 24/6. It's not that a condition is, yes, of course, condition is violated. There may be disputed thing that he has intimated, he has not intimated. all are there. It was on 18th he was arrested. Was it his not responsibility after going through the document? What should we do?
No.
Okay. This was his responsibility. This is, I think he has done in haste. He has done in haste. Because his case is that the High Court can grant bail. Let me also do, I can take the loopholes, we'll do it. This kind of behavior will not allow. Anything left? Bail to Mari Dibu ache. Gote agar kotha hen. Yes.
In supplementary list bail application.
Supplementary list bail
Item
application.
47. Six. CD was, it was fixed for CD.
Huh?
For CD it was fixed.
Okay, so Asan, don't give it to me. This is BA or AB?
AB.
Bail hearing. Okay. Case there is was not there, na? 47.
The case, 47.
CD not there. When? What is the offenses?
For this 406 and business transaction were there, Lordship, for their non-payment of money.
Were you not here at that point of time when matter was called?
Our court.
That is gone. Okay, we'll give a early date. Friday we'll give it. We'll see. He said, or how many days you are behind? AB.
It's AB.
Any interim?
AB.
Any interim?
No.
Okay, then on Monday. 27th, okay? You just correct it.
Police station.
Vishwanath.
Vishwanath, my lord.
Vishwanath will take time. So when we have granted,
On 7.
okay, 7th on 7th.
7.
Non-APS will liquid,
7.
PP source for a time, 6 for time to produce the case there.